Okay, welcome everyone. I declare open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Royal Commission's Legislation Amendment, Protections for Providing Information Bill 2026. These are public proceedings, and although the committee may agree to request to have evidence heard in camera or may determine that certain evidence be heard in camera, I will remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege unless you are given evidence from outside of Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as contempt. It is also contempt to give false or misleading evidence. Now, both Houses of Parliament have resolved that an officer of a department of the Commonwealth should not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked to a superior officer or a minister. This prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. As Chair, I'll ensure proceedings are conducted in an orderly, respectful and courteous way. I remind committee members of their obligations under the Behaviour Code for Australian Parliamentarians and resolutions of both Houses to treat witnesses with dignity, courtesy, fairness and respect. In accordance with the committee's resolutions of the 26th of August last year, this hearing will be broadcast on Parliament's website, and the proof and official transcripts of the proceedings will also be published on the website. On that note, I would now like to welcome representatives of the Department of Home Affairs, the Attorney General's Department and the Office of the Royal Commission on Anti-Semitism and Social Cohesion to give evidence at today's public hearing. Now, could I ask all of you, for the Hansard record, could you please state your full names and the capacity in which you appear today? And let's start with the Department of Home Affairs.
So, Kira Spencer, Deputy Secretary, Law Enforcement and Domestic Security, Department of Home Affairs.
Susie Williamson de Vries, Assistant Secretary, Royal Commissions Branch, Attorney General's Department.
Philippa Ing, Acting First Assistant Secretary, International and Public Law Division at the Attorney General's Department.
Anne Sheehan, Official Secretary, Royal Commission on Anti-Semitism and Social Cohesion.
Parker Reeve, Assistant Secretary, Royal Commission on Anti-Semitism and Social Cohesion.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of their respective houses. Giving false or misleading evidence is a serious matter and may be regarded as contempt of the Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. Due to the short time frame the committee is working within to complete its review, please try and answer all questions or provide information to the best of your ability, as further written answers will have to be provided within 24 hours if you do take anything on notice. And as I understand, I think anything taken on notice by 9 a.m. on Tuesday next week. Now, did you have an opening statement? Anyone here?
Senator, I do have a brief opening statement on behalf of the Attorney General's Department.
From yourself, Philip?
I also have just a very brief
all right.
one.
Well, we'll start with you, Philip. Thank you.
Thanks, Senator. The Attorney General's Department has responsibility for the legislative framework that supports the effective operation of Royal Commissions, and at present, the interaction between the Commonwealth Secrecy provisions and the Royal Commissions Act 1902 creates uncertainty for people considering both voluntary and compulsory disclosures of intelligence and operationally sensitive information. The Royal Commission's Legislation Amendment, Protections for Providing Information Bill 2026 seeks to address these issues. The bill amends the Royal Commissions Act to, firstly, establish a pathway for people to provide intelligence and operationally sensitive information to a Royal Commission without fear of criminal or civil liability. Second, protects people who disclose intelligence or operationally sensitive information while seeking or providing legal advice in connection with the Royal Commission. And thirdly, ensures secrecy provisions do not prevent people or agencies from complying with the Royal Commission's requirement to provide evidence. These protections apply where a disclosure is made in accordance with an arrangement between the Royal Commission and the Commonwealth, and where the Royal Commission has been prescribed in regulations. In the case of the Royal Commission on Anti-Semitism and Social Cohesion, these arrangements have been settled and are now publicly available. The bill also introduces a new defence to Commonwealth secrecy offences in the Criminal Code, where a person provides the information to a Royal Commission. Briefly, as the committee is aware, the current Royal Commission on Anti-Semitism and Social Cohesion is engaging with matters that involve national security, intelligence operations and law enforcement. And while Commonwealth agencies have made significant progress in responding to notices to produce issued by the Royal Commission, and indeed have already produced thousands of documents, certain secrecy provisions have prevented and continue to prevent the production of some important, sensitive and highly relevant material. The Department has worked closely with the Royal Commission and relevant Commonwealth agencies in developing this bill, and the measures are designed to give people confidence about their ability to assist a Royal Commission safely and appropriately while preserving important protections and processes for handling sensitive material. The Department has also provided today a submission to the committee, which I recognise committee members may not have had an opportunity to read as yet. Attached to that submission are copies of the arrangements that I mentioned earlier. We'd welcome the committee's questions on the bill.
Thank you, Chair, and thanks to the committee for the opportunity to appear before you today. For the committee's awareness, Commissioner Bell has written to the committee to express the Royal Commission's support for the amendments before the committee. I note the submission is now available on the committee's website. As the Commissioner stated in her submission to the committee, the Royal Commission was consulted on the development of the bill. The amendments, as Mr Ng has outlined, would enable the Royal Commission to obtain access to information that would otherwise be protected by certain secrecy provisions, and in conjunction with the information protection arrangements agreed between the Commission and agency heads, would facilitate current and former staff members and agents of intelligence and law enforcement agencies engaging with the Commission on a voluntary basis. Access to this detailed information from intelligence and law enforcement agencies is essential to deliver, to effectively discharge paragraph C of the Commission's terms of reference concerning the circumstances surrounding the anti-Semitic attack that occurred in Bondi on the 14th of December 2025. The urgent progression of these amendments would support the Commission's work, in particular given the interim report that the Commission is required to deliver by the 30th of April this year. Thank you, Chair.
Okay. And you're happy to table your opening statements for us, please? Yep.
Yes.
Okay. Okay, Senator Cash.
Thank you very much, Chair, and thank you for appearing tonight. I know our time tonight is short, so Senator Dunham and I will just interchange as is required. I will put the questions. If anyone feels that they have additional information to add, please don't be shy. Time is short. Just jump in. What I'm going to start to, just so you can turn your minds, is the legislative timing to go through the key dates. I then do want to turn to, and obviously the arrangements have now been provided to us. Thank you very much. I do want to go through them in detail though. And then obviously there are specific sections of the Act that are quite technical in detail, which I would like to also go through. So I will move through as quickly as possible. When was the legislation first drafted by the Department?
Senator, the legislation was prepared in February this year.
February this year. When were drafting instructions first given?
Yeah, early February. Senator?
In February. When was the legislation finalised?
Again, it would have been later in February. If you need an exact date, Senator, we can come back to you.
Would you? Yeah, I would appreciate that. Thank you very much. When was it put out to consultation?
During the course of the development of the bill, so that would have occurred during the first few weeks in February.
Okay. And when we say consultation, who did you consult with?
Senator, the key stakeholders that we've consulted on this bill are Commonwealth agencies, along with the Office of the Royal Commission. I can take you through.
Would you mind for the record,
those
please? Yes.
Agencies. Of course, these consultations have been a continuation of long-standing consultations in the context of a broader package of secrecy reforms that the department is leading. So let me just
I can read out for you, Senator. So the department consulted, as Ms Williamson de Vries mentioned, across the Commonwealth. So that included with all members of the national intelligence community. That includes the Australian Criminal Intelligence Commission, Australian Geospatial Intelligence Organisation, the AFP, Australian Signals Directorate, ASIO, the Australian Secret Intelligence Service, the Australian Transaction Reports and Analysis Centre, Defence Intelligence Organisation and the Office of National Intelligence. The department also consulted across a wide range of other Commonwealth agencies. I'm happy to read them out. That includes Department of Prime Minister and Cabinet, Agriculture, Fisheries and Forestry, Climate Change, Energy, the Environment and Water, Defence, Employment and Workplace Relations, Finance, Foreign Affairs and Trade, Health, Disability and Ageing, Department of Home Affairs, Industry, Science and Resources, Infrastructure, Transport, Regional Development, Communications, Sports and the Arts, the Department of Social Services, the Treasury, Department of Veterans Affairs, the National Indigenous Australians Agency and Services Australia were all a number of the Commonwealth agencies who were consulted.
Thank you. And in terms of, remind me what the date on which the Royal Commission was announced?
It was announced on the 8th of January and the letters patent were issued on the 9th.
So when did it first come to the department's attention that changes to the Royal Commissions Act, as we now have been provided with by way of the legislation, were required?
Senator, as Ms Burlington-DeVry has mentioned, this is there's been some long-running work in relation to secrecy provisions, and certainly the bill itself responds to certain recommendations that were made.
That's good. Jump straight into them, because that is actually what I was going to ask you to take me through. So please, if you could take us through them.
Yep, no problem. So the bill responds to certain recommendations that were made in the Attorney General's Department review of secrecy provisions and in the interim report of the Royal Commission on Defence and Veteran Suicide. Those recommendations were intended to improve protections for individuals providing information to Royal Commissions that's subject to a secrecy provisions, and establish a defence to the Criminal Code offences. I can take you to the specifics of those. So in particular, it was recommendation 6 of the interim report of the Royal Commission into Defence and Veteran Suicide that called for clearer protections for individuals engaging with Royal Commissions, and it was recommendation 7 of the secrecy review, which identified that need. This is a part of a broader package of work, and a number of discussions and consultations have been had on the broader secrecy review from some time. That included the aspect of voluntary disclosures, and certainly some aspects of what is now being brought forward and expedited in this bill were discussed as part of that process, including last year.
So in terms of recommendation 7 of the 2023 secrecy review and the broader discussions in relation to the secrecy reform, can I confirm, when did you commence drafting in relation to the broader discussion?
I'll have to take that one on notice, Senator, because it would have been earlier than...
Yeah, that's right. My understanding was that these were actually part of that broader reform, but you've actually plucked them out and decided to bring them forward because of this Royal Commission.
That's correct. Senator, yeah, it was throughout 2004 and into 2005, and in particular the Criminal Code defence that had been drafted. Yeah.
Can I just ask, in terms of the legislation itself, I'm only asking for a date and nothing more. Are you aware what date it went through Cabinet?
No.
I'll have to take... I don't have that date before me, Senator, so I'll have to take that on notice.
No, that's fine if you wouldn't mind doing that. Can I just ask Ms Sheehan, when did it become clear to the Royal Commission that this legislation was necessary?
I see the Royal Commission's aware of the recommendations that you've referred to around voluntary disclosures. As
per the previous secrecy review findings,
as per previous
and
public...
the Veterans Royal Commission findings, yes?
That's correct. When the Commission started its operations in January and started issuing notices to produce, it became apparent that some secrecy provisions were causing limitations. So, for example, the Telecommunications Interception Act. We had discussions with the department, including the Attorney General's Department and Home Affairs, around those limitations. A ministerial declaration was made under the TIA Act to facilitate the provision of information, that we can take you through the dates that
Would you mind, and what
made.
the effect of that was?
I can do that. Let me see. Sorry, I'll just make sure I give you the right dates. So on the 21st of January, we spoke with with Home Affairs around the need for a ministerial declaration to be made under Section 5AA of the TIA Act, and that the purpose of that declaration is to declare the Royal Commission as an eligible Royal Commission under the TIA Act.
And just remind, what is the effect of that?
I might get my colleague to expand.
Yep.
Thank you. The effect of that, Senator, is to allow the Royal Commission to receive intercepted information and information about warrants obtained under the TI Act,
Right.
For the purposes of its investigations as a Royal Commission.
Yes.
And then to use that information in the course of the Royal Commission.
Okay.
So on the 21st of January, conversations with Home Affairs, and then on the 22nd of January, conversations with Attorney General's Department. On that same day, on the 22nd of January, a draft declaration was provided by Home Affairs, so they engaged very promptly and prepared a draft declaration immediately and shared that with the Royal Commission for our consideration, and then they put that to their minister, and that declaration was made on the 27th of January. So that declaration was made.
Yes.
It was then, I think, became clear that there were still limitations on the provision of information to the Royal Commission.
How do you become aware? Like, the Veterans Royal Commission basically told us in terms of the limitations they had, a workaround had to be put in place. The Secrecy review also said that there is obviously issues. So just in terms of that timeline, do you start receiving the submissions, or are they not able to provide you with the submissions?
Agencies haven't been able to provide all the information that they've been
Right.
requested under notices to
And
produce.
they say, because of the secrecy provisions, we're unable to provide it. Go and
Yes.
sort it out,
That's correct. So,
and then understood.
yeah,
Okay.
so throughout February, conversations then continued with the departments around inclusion of those provisions in this bill.
Okay. So then drafting instructions were given, and you'll come back with all the absolute specifics on them. In terms of the arrangements, when did you first commence work on them?
Senator, I think work was commenced quite soon after the letters patent were published.
I don't have an exact date, but the work would have commenced in January on those. The letters patent refer to the need to prepare these arrangements. It's paragraph I of the letters patent. So that commenced in January, and drafts we've worked constructively between the Royal Commission and the department and relevant agencies, and then they were concluded around a week ago.
Yeah, on Friday.
Okay. And we've only just received them today. They're published now?
Yes.
Okay. So around January, pursuant to the letters patent, you knew that you had to have arrangements in place to allow the provision of information, but without the legislation, what would happen under the arrangements?
So we can walk you through in more detail what sorts of things the arrangements set out, but the arrangements would need to...
Let me just go through and I am the one jumping around, I know that, because I do want you to take me through in detail.
Senator, I was just going to add the arrangements would need to be in place regardless of the need for legislative amendments.
That's what I was going to ask.
Yeah,
okay.
because they deal with things like how do you appropriately access material, store material, handle it, include provisions around, you handle it in accordance with the protective security policy framework. So, we can take you through some of that detail, but they're in place regardless of legislation.
So when the Act refers to the provision of information, pursuant to the arrangements, they are now able to provide the information they would, or they will be able to provide the information that they would otherwise be unable to provide pursuant to these arrangements. These are the arrangements that have been referred to.
Yes, under the bill, if that's correct. So what the bill would do is provide, and where the information is provided consistently in accordance with the arrangements, the bill then provides an immunity from the Commonwealth secrecy provisions where they disclose this type of sensitive information to a Royal Commission or to their legal representative. I can go into some detail about that. Really that kind of additional protection comes with reference to the arrangements that Ms Sheehan has been discussing.
Right. When I got the arrangements, there are two arrangements, correct?
Yes.
The first is disclosing operationally sensitive information. The second is information relating to an intelligence agency. Because we haven't had a chance yet, obviously, to review them, why are two arrangements required? And if you could take us through what they're for.
Sure. So, as you pointed out, Senator, one arrangement relates to intelligence information, the other relates to operationally sensitive information. It's probably useful just to start with a quick definition, just because that's reflected in the Act, and that is because that distinguishes between the two. The first is intelligence information, which is information acquired or prepared by, or that relates to the functions of an Australian intelligence entity. So that would also cover information that identifies, for example, a person as a staff member or an agent of ASIO or ASIS. So that is Australian intelligence entity information relating to their functions or prepared by them. Then on operationally sensitive information, we're talking about a broader range of categories, information held by law enforcement or security agencies about operational methods, sources, investigations and related proceedings, as well as information provided by foreign government. So I'll pass to Ms Willington de Vries in a moment just to explain it in more detail, but the two arrangements reflect the two different categories of information.
Yeah, correct. Senator, the intelligence information arrangement has been agreed by relevant agency heads of the relevant intelligence agencies, because this document is intended to focus and address the secrecy provisions that are set out in their governing legislation. So that's the Intelligence Services Act, the Office of National Intelligence Act, the Australian Security Intelligence Organisation Act, along with, of course, the general secrecy provisions in the Criminal Code, Division 122. So this, and importantly, I think, is Part 4 or Paragraph 4, which is by their signature or their authorisations, those agency heads are approving the provision of information consistent with these arrangements.
Okay, just hold on for one moment. I'm trying to find those signatures on that particular one.
Senator, we have not provided signed copies. What we have given, the signature page is on 21 to 24, but we haven't provided the personal signatures of agency heads, but we can assure you that
just hold on for one moment. I only got a 20.
Sure.
Oh, yes, apologies.
I have your page 20. Just to confirm that the documents have been signed by the parties listed.
So can I get you again? I do apologise. I just need it all on the public record then. Who signed the documents? I know. Can we focus on the intelligence agencies, please? So
on page 1 of your document, although slightly confusingly there are 2-page ones, but under parties, Senator,
right. So we're there.
I'm happy to read it out for the public record. But
yes, please.
The arrangement is between the Royal Commission on Anti-Semitism and Social Cohesion and the Commonwealth, as represented by the Secretary of the Attorney General's Department, the Director-General of Security, the Director-General of the Australian Secret Intelligence Service, the Director-General of the Australian Signals Directorate, the Director-General of National Intelligence, the Director of the Defence Intelligence Organisation and the Director of the Australian Geospatial Intelligence Organisation. And so those are the parties to the arrangement.
And can I just confirm, they are the intelligence agencies, they are affected by the secrecy provisions of their acts, and they are the only ones that are affected, and that's why they are included in here. There's nobody else?
That's correct, because it's the intelligence information that relates to those agencies. So it's those agency heads that are essentially enabling the provision of information to the Royal Commission.
ONI?
Yes, the Director General of National Intelligence.
ONI. Thank you. Okay. In relation to the arrangements, what was the consultation process with each of the parties that are reflected under page 1 parties? And also, why do we do one set of arrangements as opposed to individual arrangements with each party?
Senator, so to give you a bit more background about the genesis, IGIS, who of course is listed as the owner of the arrangement, is representing the Commonwealth in its engagement with the Royal Commission. So it has drafted the arrangements on behalf of relevant agencies who it is representing.
Right.
In terms of why they are not, I think there's just no need to have separate arrangements, that they're all intended. It
would be the same
achieve,
arrangement, hence you're able to list them under
different
parties.
legislation, but intended to achieve the same thing. Also, it signals the same cooperative approach by the Commonwealth to the Royal Commission.
When you say the Commonwealth negotiates the Attorney-General's Department as the representative, what's the process by which you go to each agency head, though, to say, are you satisfied with these arrangements? Do they cover everything that we need? Are any changes needed to be made? Is there a process that you go through?
Yes. Yes, Senator, that describes very much the process. So there is engagement with each of those relevant agencies at initially, of course, as you would expect, at officials level, but there is strong engagement within each of those agencies as well as within the department on the precise terms of the arrangement and to ensure that it achieves what are the intended objectives for it, which of course is to ensure both the security of the sensitive information that is held and recognising that, as well as really establishing appropriate arrangements for the obtaining and storing and accessing and provision of that information.
Okay. Does the Royal Commission itself, because the arrangements are between the Royal Commission and the Commonwealth, so what's then the Royal Commission's role here?
A draft of the arrangements was shared with the Royal Commission. We consulted internally within the Royal Commission, so our solicitors assisting and counsel reviewed them, as did the Commissioner.
Okay. Did any agencies provide feedback whereby they raised concerns with the arrangements?
Senator, certainly it's been an iterative process, so there's been input by agencies, so there's been genuine consultation back and forth. There have been amendments suggested by agencies and agreed, again, back and forth.
So in terms of then, and thank you for that, the final arrangements that we have, each of the agency heads, B through G, are they satisfied that these are sufficient? Would they like changes made to them?
Certainly, there is the opportunity to make changes.
How does that work?
So I might just answer your first question before, which is just to say they are comfortable with them as reflected in their signature of the final product. So they were signed very recently. They are, and that really reflects the agency's full agreement to the terms of the arrangements. While there are provisions, as in any contract, for variations, and that's in clause 11. But to address your first question, Senator, they have the agreement of all the agencies.
And thank you for pointing out clause 11. Again, we only literally just received them. So I do just want to now go to clause 11 to have a very brief look at that, because that does answer my question. In the event that the Royal Commission says we still can't access, or an agency says we're not providing it, Clause 11, variation. Oh, 13.
It depends on the... Yes, it's 13 probably in the arrangement that you are looking at, and the other arrangement, it is Clause 11.
Oh, understood. But this arrangement may be varied at any time with the agreement of the parties.
And Senator, the bill requires, obviously the arrangements need to be published as a notifiable instrument by the AGD Secretary, and that includes, of course, any variations in the future.
Okay. You mentioned were signed recently. Do you have the dates upon which the arrangements were signed?
The arrangements were signed by all parties on Friday the 27th of
Friday
February.
the 27th.
Yep.
Okay, thank you. Friday the 27th. Schedule 3 of the bill provides a defence, and I quote, where a person communicates or deals with information for the primary purpose of providing it to the Royal Commission, and the person has a reasonable belief that the information was relevant to the Royal Commission's inquiry. End quote. Can I put a scenario to you so I better understand how this will actually work? If an intelligence official removes a classified document from a secure facility with the intent, so the clear intent, of providing it to the Royal Commission, for the purposes, obviously, of the Royal Commission, and determines to do so voluntarily without prior approval of their agency, under the bill, would they have an immunity from prosecution, or can they still be charged but would have access to a defence?
So, if it's all right, Senator, I might answer that question just by pointing out what the new defence does, which is it's a defence from the general secrecy offence under Div 122 to the code. Does not extend to specific secrecy offences that might be found, for example, in the ASIO Act or other relevant acts that we've referred to that exist elsewhere. So what we're talking about, just to clarify, what we're talking about in relation to the defence that you mentioned in Div 122 is a defence to the general secrecy offence.
Right.
Without obviously providing legal advice, but in the hypothetical situation that you mentioned,
yes,
the person would likely have obligations under secrecy offences that exist in relation to their. I'm just trying to remember whether their employment in the organisation, I think, is the example you gave.
Yes, correct.
So the defence that applies under the general secrecy offences doesn't give you a defence, for example, and I'm just picking the ASIO Act as an example, as a defence from the ASIO Act, secrecy offences.
So can I then clarify how you will understand voluntary disclosure? Does it include instances in which an official decides on their own? There is a Royal Commission. It's looking into these terms of reference. I work for an intelligence agency. I have access to information legitimately. It's in my possession legitimately that I know will assist the Royal Commission, in particular when it comes to its inquiries into the activities of the intelligence agencies. I haven't been compelled by the Royal Commission to provide this information, but I know you need the information. How do I provide that legitimately and ensure that I am protected from both the secrecy provisions and anything else?
So in that example, Senator, the arrangements and what is set out in the arrangements sets out really what is the process for someone in that hypothetical situation making a form of disclosure.
Can I get you to take me through, and can we look at the intelligence agency's arrangement purely so that we're working on the same document? Because that's the concern that has been raised with us, and hence why I do want to pursue this, that there may well be people within the agencies legitimately in possession of information. They legitimately want to provide it to the Royal Commission so that you can review it, but they are not sure as to what their protections will be.
Senator, and we hope that this bill clarifies that. The key provision is section 6PD of the bill.
Yes.
Or other clause. So this is what provides the protection for individuals, and it outlines some conditions, which is that they can be giving information voluntarily give information or a document that they believe is relevant to the Commission's inquiry. They obviously can make a statement or give evidence, make a statement in writing, and the information is of this nature, which is intelligence information or operationally sensitive information, and key here, that the giving, making or production of that information, document, statement or disclosure is consistent with the procedures that are published in the arrangements. So it does require the person to provide the information in a way that's consistent with the arrangements, and if they do so, they'll be protected from liability at subsection 2.
And just in relation to liability at subsection 2 of...
Oh, apologies, of clause 6PD, which is that the person does not commit an offence and is not liable to any penalty under a secrecy provision for giving, making or producing the information, document, statement or disclosure.
Okay. And again, because we're doing this in such a short time frame and such a short turnaround, I suppose what I'm probably getting to is, and I'll ask the Royal Commission to just take us through the process in terms of how you're actually calling people, etc. I haven't heard from you. I don't know who I know who you are, but I haven't heard from you. I work for an intelligence agency. I've read the terms of reference. I know that I've got the information. I need to get it to you. I get it to you, and you can tell me shortly how I'm going to do that. Is that situation covered from the secrecy provisions? Like a whistleblower almost.
Yes, we say that so long as it's that type of information and it's in accordance with the arrangement, then it is then a person has an immunity from criminal or civil liability, and of course a use immunity too.
Yeah. How do they invoke that immunity? If I'm challenged and I am a person who's come forward voluntarily, I am then told you're actually in breach. How do I invoke the immunity? What do I need to prove?
Oh,
1 minute.
yeah. Yeah, we understand that you'll just plead an immunity.
Okay. So again, I just want to, because these are the issues that are being raised. Can I clarify how you will understand what we're calling voluntary disclosure? Does it include instances in which an official decides on their own and essentially in secret to provide information to the Royal Commission outside of any agency process?
Yes, Senator, it does.
Thank you.
And again, so long as it is consistent with the arrangements, and maybe we can take you to
let's go through that. Yes,
paragraph 5 of the arrangement. So again, paragraph 5 of the intelligence agency arrangement.
Yes,
perhaps is the best.
So if you look at 5.1, Senator, you'll see 5.1a, and it includes a situation where a person seeks to engage with the Royal Commission on a voluntary basis. So that's the voluntariness that's there.
Sorry, I must be looking at the other one.
Sorry, 5.1a says the Commissioner... Sorry, there's an or in 5.1a.
No. Understood.
Sorry,
yep.
I can...
Sorry, now I've got it, yep.
I can see why that's confusing. But if it says and I'm just reading straight, if a person seeks to engage with the Royal Commission on a voluntary basis...
Yes.
And then you'll see in B, the Commissioner or a staff member of the Commission reasonably suspects that the person may knowingly or inadvertently disclose intelligence information when when engaging with the Royal Commission on a voluntary basis.
Yes.
Then the Commissioner or the staff member of the Commission, as relevant, agrees to request that the person inform the a staff member where their response may involve the disclosure, and sorry, now I've jumped into 5.2.
Yep.
Where their voluntary engagement may involve disclosure of intelligence information, then the Commissioner or a staff member of the Commission will make arrangements to receive that information.
In accordance with the protocols.
That's correct. Well, yes, that's right. That's set out in the arrangements, and you'll see there in 5.2 some of the criteria that apply, including that they are handled securely in accordance with the requirements of the protective security policy framework that would apply to the classification of some of, depending on the classification, or really of any classified government information.
So, Senator, we really distill the requirements on the individual down to 2 key points, which is if they think that through their voluntary engagement they may disclose intelligence or operationally sensitive information, they firstly have to inform a staff member of the Royal Commission. And secondly, they need to await further instructions from the Royal Commission, who, of course, as Phil says, needs to make arrangements to receive that information securely, and that includes through or either a private interview or in a confidential hearing at which the Royal Commission itself needs to ensure that only authorised persons are present to receive that information.
Okay.
And at a high level, Senator, that's of course intended to ensure the protection of necessary national security information, but to enable the clear lawful pathway for a person to be able to provide that information.
Okay. What if they don't do that and they provide the information in a public hearing?
So at that point, Senator, you would be outside the terms of the arrangement specifically provides for certain requirements. In your example, I guess it would depend on some of the additional facts that sit around that. I don't know whether Sharon has something to add on that.
Maybe just at a broad level, though, we'd say that the immunities, these kind of quite generous immunities in the Royal Commissions Act would not apply. So the the defences to the secrecy offences under the criminal code would apply, but this kind of broad immunity from criminal and civil liability would not attach to the person.
Okay.
And I'm not sure if you have.
I was just going to add to the answer by saying 5.2 also sets out where a staff member of the Royal Commission reasonably suspects that the individual's providing information that's intelligence information. So it's not just up to the individual to advise that the information might be intelligence information. There's that, and obviously there's a matter of judgment, and we have staff members that are well experienced in dealing with classified information to exercise that judgment. The scenario at a public hearing as well, there would be, from a Commonwealth representation perspective, their legal representatives at a hearing and able to be able to indicate that certain information is not appropriate to be heard in a public setting, and then the Commission could consider and make arrangements for that to be heard in a different setting.
Okay. I am not sure if we're going to be hearing from any of the agencies, but as you've said in relation to the signature page, it is the Commonwealth on behalf of. Can I therefore ask, and my understanding is there has been, as you've articulated, thousands of submissions have come forward. How is each agency going to clearly communicate with all of their staff that if you want to provide information to the Commission, you must be aware of these obligations in the event that you will need to invoke a immunity?
I could provide some information from the Royal Commission perspective, and the Department might want to add from the Commonwealth perspective, or agencies themselves can advise how they intend to deal with it. So we have put the arrangements themselves are on our website now, but we are also preparing some more simple guidance for individuals that will go on the website, or if they are seeking to voluntarily engage with the Royal Commission, that they understand the crux of what's in the arrangements in just more simple terms. So that guidance would be on the Royal Commission's website as well, to give guidance from the Royal Commission's perspective. And then, as you say, agencies may wish to provide their own guidance to their own staff.
What is your expectation from agencies in relation to... I mean, this is very serious. This is why we're here today, obviously. This is secrecy laws. What is your expectation to agencies? These have now been published. Certain protocols are being put in place. How will people understand they are able to provide this information as a person who has not been compulsorily asked to, and they are also able to get effectively an immunity?
So, Senator, we've had very strong positive engagement from all of the agencies, and I think what I would say is, while of course it's a matter for the agencies to determine within their scope kind of how they promulgate it, they are very conscious of the requirements that are set out under the arrangements. They would also have the benefit of the fact that these are publicly available, of the guidance that Ms. Sheehan has mentioned as something to point to as the lawful mechanism for such information to be provided.
The concern that's been raised is one of the terms of reference obviously is actually looking at the agencies themselves. So I have great faith in our agencies, but the concern that has been raised is, given it's the agencies that have been consulted in relation to the arrangements, given that they have signed off B through to G, is there anything in these arrangements and the Royal Commission bill that we're inquiring into that would in any way preclude someone coming forward with a voluntary disclosure and they are not able to invoke the immunity if they have complied with the arrangements and the protocols? In other words, can an agency stop someone coming forward and giving information?
There is no ability within, and as you've seen from paragraphs 5.1 and 5.2 of the agreement, so the arrangement, Senator, there is no, as part of that process, you will see there is no mention there of the any other official within a relevant agency, for example, having a role in that direct engagement. That is a separate question from potential publication and other issues that relate to that information. But in terms of what is set out in 5.1 and 5.2 about how intelligence information is received from individuals, there is no process requirement that would go through, for example, the relevant head of an agency.
And Senator, if I might just...
Thank you. As I said, please, it's fluid. Thank you.
From the Royal Commission's perspective, we are also satisfied that, provided that an official complies with the process requirements, which are appropriate to protect sensitive information, that they would be able to approach the Royal Commission and, going through that process, provide information to the Royal Commission on a voluntary basis. We are satisfied that there is not an ability for an agency to preclude that from occurring.
And can I ask, I've used a certain word, you are using very specific language, and again, purely because I want to get this on the record, you say official, I said a member of the agency, a staff member, an employee. Can I ask what your definition of official includes?
I beg your pardon, Senator, I'm going to turn to the definition.
No, please, quite seriously, exactly. Yes, I just want to ensure that every single person who works at an agency that is part of parties on page 1 is able to, should they wish to, provide a voluntary disclosure to you in accordance with the protocols.
I think it does just use the term person, yes.
Senator, if I can assist, I think we use the term person in the arrangements, and that is deliberate. It is any person. So that is doesn't really need a further definition, but I, of course, would include officials and, I'm sorry, I've forgotten the other category, but the other categories that you're mentioning. Employees.
I work for an agency. I happen to be in possession of information.
That's right.
It's legitimate information. I'm entitled to access it. I haven't been called. but I want to provide it. I'm included within that scope.
Yeah. That would be a person as sort of referred to in that relevant section 5.
Thank you very much. I just want to go to...
Senator, if I might just...
Yeah, please, thank you very much, Mr. Ray.
And then Section 6PD of the Act then, quite importantly, also refers to person. So the provision of the legislation that actually provides the statutory protection from secrecy offences is similarly broad.
6PD provides that a person's disclosure to the Royal Commission... Yep.
Yes.
Understood. Thank you very much. Could I just go now to the definition of intelligence information? There was, I now have noted, a replacement explanatory memorandum that states that, and I quote, "The term intelligence information is defined in the same terms as the Intelligence Services Act 2001 and the National Anti-Corruption Commission Act 2022. That's at page 18, or paragraph 18, page 11 of the updated explanatory memorandum. However, the definition is only in similar, not exact terms as the next definition, and is not similar at all to the definition in the Intelligence Services Act. More importantly, it does not reflect the language used in the ASIO Act, which refers to employees and affiliates. Is that a drafting error? Is it a deliberate policy decision? And what assurances are there that employees and affiliates of ASIO are covered?
So, Senator, that definition of intelligence information was helpfully sort of agreed by all parties to the agreement as an appropriate coverage for the type of information that might be provided. It was, as I think the explanatory memorandum notes, sort of framed broadly to ensure that all information which had potential national security implications would be captured. We referenced those other acts to show, by way of example, to show where the definition is drawn from, but the specific definition that is of intelligence information that is in the Act is one that has been, I will say, carefully reviewed by every agency who was, particularly intelligence agency, consulted on the bill, and was thought to, as reflected in the memorandum, to cover and ensure that all information with a potential national security implication is caught by that.
Okay. Just in terms of the previous line of questioning and whether or not, or to whom the immunity would ultimately apply, is there an ultimate arbiter of whether, and I will use the word official with its broad definition, can give information to the Royal Commission in accordance with the protocols?
Sorry, Senator, do you mind repeating the question?
Is there an ultimate arbiter of who can give information to the Royal Commission? Is anybody able to block me from giving information to the Royal Commission?
I think it would ultimately be up to the Commissioner to determine what information the Royal Commission can receive and make a ruling on that as appropriate.
Okay, so the Commissioner ultimately, so the Minister is not able to?
There's no ability for the Minister to do that.
None of the agency heads are able to block the information going to the Royal Commission?
In terms of the actual provision of the information from the individual to the Royal Commission, there is no, with the bills and the effect of the arrangements is to provide, there's no ability for an intelligence agency head or a minister to block the provision of that information. Okay. There are separate provisions that deal with subsequent handling and publication and reports and things like that from the Royal Commission, but the actual act of, and it's in that paragraph 5.1 and 5.2 that we were discussing before, the actual act of provision of that information is a direct process between the person and the Royal Commission or the relevant staff member of the Royal Commission.
Just, again, just out of interest, and thank you for saying that, If a person wanted to give information and the agency head knew about this and decided they did not want that information given to the Royal Commission, or alternatively, the Minister knew information was going to be given and they did not want that information to be given, and influence, pressure, however so defined, was placed on that individual not to assist the Commission, is there a penalty? Is that criminalised?
Senator, sorry. I beg your pardon. Susie, if you were about to...
You understand what I'm saying? Is someone able to influence another person to not actually provide information to the Commission when that person, the whistleblower, the person not officially asked to give information, knows they've got to get that information to the Commission?
Senator, so the Royal Commissions Act itself contains offences for preventing a person from...
Yes. Can you take me to them, please?
So that's Section 6L of the Royal Commissions Act.
Thank you.
There are also a separate offence for contempt of a Royal Commission at Section 6O. Section 6M deals with injury to witnesses, which covers more than physical injury.
Yes.
Section 6N of the Royal Commissions Act deals with dismissal. If a person is, for example, dismissed because of providing evidence to a Royal Commission. So the precise circumstances...
I think you've answered my question. Someone tries to put pressure on me not to come forward. I can then, the protections are already there in the Royal Commissions Act to say, so just take me through the penalties for that, if that is actually proven.
So we'll take you through the penalties in just one moment, Senator. I will just say that these are specific provisions in the Royal Commissions Act. In the circumstance you described, there may well be other criminal penalties that civil remedies or other penalties that apply. So particularly in the employment context. That I wouldn't. While these are significant and there's potential imprisonment for up to 1 year for injury to witness, for example, or dismissal of employers by employers of witnesses, and preventing a witness from attending would be imprisonment for 1 year, and in some cases 10 penalty units. That was the answer to your question, I think. But I just want to point out these are specific Royal Commission penalty offence provisions, but there may well be other ones that apply as well.
And thank you for that. I appreciate that answer. Were you going to say no, Mr. Reeves? In terms of the ultimate arbiter, can you just take me through, Ms. Sheehan, how information is actually received by the Commission in that voluntary capacity? You already have the ability to ask me to provide the information and for me to provide it to you through the protocols. If I come to you and I want to provide you with that information, how does that actually occur? And is it the Royal Commissioner herself who makes the decision as to whether or not to receive that information? And do they have to provide reasons to the person? And does the person ever know whether or not their information is ultimately received by the Royal Commission?
So, in terms of how information generally is being provided to the Royal Commission, at the moment we have opened up for public submissions, so people can contact the Royal Commission to make submissions in relation to any of the terms of reference. We have, in relation to the sorts of voluntary disclosures that we're talking about here, a small number of individuals have contacted the Royal Commission to indicate an interest in providing that information. That is being handled by our Office of Solicitors assisting the Royal Commission in discussion with our counsel as to how that information would be taken. So there's not, necessarily like a set way. It would not have to be the Commissioner herself that takes it. It could be through her solicitors assisting or through counsel. Yeah, that would just be worked through as to what was appropriate in the circumstances.
Okay. Just going back to, I just want to go back to the provision of information. Again, it's concerns that have been raised with us, which is why I'm asking these questions publicly. The concern is that if an agency head is adamant that certain information has national security implications, but the Commissioner believes that the information is vital for the work of the Commission. How does the Commissioner access that information?
Well, the information arrangements don't allow the agency head to prevent that information from being
it absolutely is in place. There's no the agency head trumps anybody else. We're not providing the information to the Commission because of its serious national security implications. That is now all going to be taken care of.
Yeah, so what the information arrangements provide for is to how it will be taken. So as Ms Williamson de Vries set out, it could be taken through a private interview with the individual, or through a private confidential hearing. So it's about having the appropriate arrangements to protect that information in place. So, you know, as you were referring to before, not doing so in a public setting, because the Royal Commission does have obligations to ensure that information is appropriately protected. And then there are provisions around ensuring that the Royal Commission uses that information in an appropriate way. So it doesn't prevent the access to that information, but the Royal Commission would, and this is referred to in the letters patent as well, to protect the information in, for example, in preparing its report. Would consider what's appropriate, for example, to put in a public report.
Just in terms of those who work on the Royal Commission and the evidence that once this is put in place, you will be given access to, do they need to have the top level of security clearance to actually access the information? What are those security arrangements?
We have staff with high-level security clearances working in the Royal Commission.
Is it secret or top secret?
Both.
Yeah. And so do you have your own protocols in place? It's very serious, obviously, if any of this information gets out. So those staff members will all be security cleared at the highest level?
Yeah, staff that are accessing information that is classified would have the appropriate security clearances in place.
Okay. Sorry, Raph. Sorry.
The arrangements themselves refer to compliance with the PSPF, which is a protective security.
And the commissioners themselves, they have...
The commissioner doesn't have a requirement for...
Because they are the commissioner?
The commissioner, but staff of the Royal Commission that have a need to access classified information would have a security clearance.
Okay. Sticking with the arrangements... they've been finalised. They are now available on the Commonwealth's website.
On the Royal Commission.
Oh, the Royal Commission, sorry. The Commission's website, sorry.
And Senator,
it's currently on... Yep.
Oh, sorry, just to mention, they'll also be published as a notifiable instrument as well.
Yep, thank you very much.
Sorry, that's if the bill is passed.
No, understood. Thank you for that qualification. Yes, exactly. No, I appreciate that. Can I just go back to, though, and this is important, though, given the conversation that we are having, the Attorney General's Department and potentially the Royal Commission. The evidence being provided will be coming from these agencies in relation to this particular term of reference of the letters patent. Can I just go back to what is your expectation as to the guidance that is going to be given by each of these agencies? You now have a document live on a website that provides the arrangements under which I'm able to provide to you on a voluntary basis classified information. I would have thought there would be an expectation. Yes, it's a notifiable instrument. As you and I know, that means nothing to anybody other than us in this room. I would have thought that a clear expectation has been expressed to agency heads to ensure that people do understand that they are able to provide the information to the Royal Commission.
And Senator, what I would say on that is, in all of our engagement with every one of the agencies, they've expressed a commitment to these arrangements. I'm aware, even before these arrangements are finalised, some of the agencies made it very clear to their staff members that they should engage with the Royal Commission if they felt like they welcomed the engagement with the Royal Commission. Is probably the best way to put that. And they are very conscious, and while it's of course a matter for those agencies to comment on their own affairs, that they are, in our experience, very conscious of the need to support the Royal Commission and its very important job, and have reflected that at all levels within their agencies.
No, and as I said, I do appreciate that. The issue I may have is that, again, I don't know if we will be hearing from the agencies, so I do therefore have to direct the questions to you as the Attorney-General's Department, or should I say the Commonwealth as represented by. I mean, it may well be a recommendation of the committee then that we actually ask you to provide a very clear direction to the agencies that within a specified time frame, probably 24 hours from any release of a report, this is just hypothetical, that they actually inform each and every staff member clearly in writing of what they are able to do, the arrangements and their obligations. Because I understand what you're saying. My concern is if I can't get these assurances from the agencies, that really is going to be the only way that we're going to be able to do that, but that is to make a recommendation. In the event a committee made such a recommendation, the department would be able to do that. Clearly,
we're in very close consultation with the agency, Senator. We play a leading coordination role, as you'd be familiar with each of those agencies. So we are in regular dialogue with them.
No, and as I said, I just don't know if I'll be hearing from them.
Certainly we can communicate it, we can't require it. But I think, Senator, as we've said throughout, the agencies and the Royal Commission have this really strong mutual interest in ensuring that everyone is getting the information to the Royal Commission, but in the safest possible way. So we wouldn't anticipate any issues. No,
and thank you for that. Just in terms... Oh, sorry. Yes,
sorry, if I may. Obviously, I can't testify on behalf of the agency, so won't be able to address that part of your question. But if I can just take you briefly to paragraphs 4.2, 4.3 and 4.4 of the arrangement, just to highlight that these arrangements actually constitute a statutory authorisation under the ASIO Act, the Intelligence Services Act and the Office of National Intelligence Act. And similar authorisations are given by the heads of those agencies in the performance of their ordinary functions, setting out how information obtained by those agencies can be communicated and like. My expectation is that those arrangements generally are made known to all staff because they are the statutory arrangements.
Thank you very much for that qualification.
For the purposes of those agencies that cover all of their functions. So I don't think that detracts from your question.
No, it doesn't.
I think it is an important point to highlight.
Additional information. Thank you. In terms of the Royal Commission at this point in time, what secure facilities, information technology systems and personnel clearances does the Commission currently have for receiving, storing and handling classified material?
From a personnel perspective, we have a number of staff with the necessary clearances to receive and view the information, and we have access to secure facilities and secure terminals, computer terminals to be receiving that information.
Understood. So the Commission currently has the capability to handle material at the classification levels that the intelligence agencies hold?
Correct.
And that has been assessed properly in accordance with any requirements?
Yes.
Okay. Have you received any information yet of a classified nature absent these arrangements? So, okay, that's just what I wanted to get to then. So, very similar to the Veterans Royal Commission. What is the process currently for receiving that information, and what are you currently doing with it?
So the Commission issues notices to produce to various agencies, and information is received pursuant to those notices, and that is across a variety of, it might be on the protected level, so it can come on the, I guess, more ordinary computer system. If it's secret or top secret, then it's provided to us on the appropriate secure facilities, and then that is, as that information comes in, it is being reviewed and assessed by staff with the necessary clearance or the appropriate clearances for the level of the information received.
Okay. And in terms of the impact of this bill, what will its impact be on the information that you currently have?
It will enable some of the information that hasn't been able to be provided to the Royal Commission, for example, because of the secrecy offences under the Telecommunications Interception Act, that would be able to be provided to the Commission. So it's very important that we're able to see all the information that we've asked for. So that's one example of a category of information that hasn't been able to be provided to us yet.
So you've issued the notice to produce?
Yes.
In relation to it. Are they publicly available?
No.
No, so none of that is, okay. But it's now public information here because this is a public hearing?
We have issued... Yep. I don't think it's a secret to be saying that we've issued a number of notices.
You've issued the notices to produce, but the intelligence agencies are saying to you...
So some information's been able to be provided, and agencies are being
doing what they can.
Yeah, doing what they can, being very cooperative. But there are some categories of information where they have considered that secrecy offences have prevented them from providing it, and the TIA Act is one example of that, where these amendments would enable that information to be provided.
Okay, thank you.
But certainly information is flowing in pursuant to those notices already, and that information is being considered by our staff.
Okay. But not the information.
But not everything. Yeah. So we would very much like to be able to receive all the information that's been requested, particularly given the time frames that the Commission has to operate under.
Okay. you've answered a lot of my questions, which is great as we go.
Senator, maybe I can provide a perspective from the Attorney General's
that would be
Department.
Thank you.
We have provided, pursuant to notices, kind of many hundreds of documents without issue, but there are some final documents that we've had real challenges with. We don't hold any telecommunications interception information that's relevant to this Royal Commission, but information obtained under the Australian Crime Commission Act and the Anti-Money Laundering and Counter-Terrorism Financing Act has caused us to make sure that we're crossing I's, dotting T's, getting a necessary authorisation. So that has caused the delay with that kind of the last bit of material to the Royal Commission.
Just very briefly, I want to turn to the Criminal Code defence shortly. In relation to the immunities as per the arrangements, just to confirm my understanding, and please jump in to provide any further information. The bill passes, the arrangements are in place. Does that automatically turn them on?
So, the bill, if I can take you to the relevant provisions of the bill where the immunity applies, where the arrangements, so there's an obligation for the arrangements to be published in 6PG that is mentioned there. The immunities that are reflected, the sort of use immunity, if you like, is reflected in the fact that it has to be provided, the language is in accordance with in accordance with an arrangement. I'm just trying to find the exact provision for you. That arrangement, as we've indicated, has been finalised. So the bill comes into force, the protection that is then provided under the bill will follow.
So on proclamation, basically?
Yeah, yes. And the application provisions...
Or the
application provisions on page 10 of the bill provide that they essentially commence immediately, regardless of the fact that the Royal Commission was established before the establishment of the bill.
In terms of the turn-off provisions, because one is turned off, one's going to be a permanent change to national security architecture. Just take me through how effectively the turn-off provision works. When is the exact point of turn-off, and what happens to a person who then would provide you with the information without actually understanding the provision's been turned off, it no longer applies?
By turning off, do you mean, Senator, so the way
the immunity stops. So the Royal Commission finishes, and I want to now provide you with some more information. I didn't know that. I thought this was permanent.
Well, I guess the Royal Commission wouldn't exist anymore. So once the Royal Commission delivers its final report to the Governor-General, there wouldn't, I guess, be an entity for the individual to engage with to provide that information.
Can I interrupt? Sorry.
Yeah.
Because I'm hearing you.
You don't understand? Yeah.
So, is there any retrospectivity then? Is where you're going, isn't it? If these provisions and these arrangements are set in place, and then they are, to use Senator Cash's words, they're switched off. Is there any retrospectivity about you've provided information and therefore the protection is no longer in place? I think that's what you're trying to say, isn't it?
Yeah. So basically, a Royal Commission stood up. This is going to be a change to the architecture in terms of you can then prescribe by regulation, the Royal Commission, this comes into place. The Royal Commission finishes, this is no longer in place. The day after, bang, I had some information I provided. It's all over, basically. All bets are off. We're back to the normal.
For information provided during the course of the Royal Commission, do you want to answer?
So information provided during the course of the Royal Commission is absolutely covered by by the immunity provisions.
Yes.
As it says, it is provided if it's provided to a commission, and that immunity is ongoing in the sense of if it has been provided during the course of the Royal Commission.
I understand that the immunity is ongoing.
And that someone was to later bring an accusation or an allegation that it was provided improperly, then the immunity that was given to that is enacted for the individual, for the person, would continue to apply in relation to any allegations that were brought for a potential breach of a secrecy offence. It could be pleaded as indicated.
But once the Royal Commission is officially closed, this is no longer available to me.
Well, the ability to provide the information to the Royal Commission ceases because...
No, that's what I mean. Because, exactly, yeah. But meaning also, if I suddenly tried to give you some intelligence information... you understand the way I read the bill was these protections turn on with the Royal Commission once the Royal Commission is prescribed by legislation. Once the Royal Commission is finished, it's not there. You actually do not need to prescribe a Royal Commission to utilise this. You might decide you don't need to turn these on. But in relation to the criminal code offence, that's permanent change to the architecture going forward.
Correct.
That's right. Yep. The Royal Commission would be, on anti-Semitism and social cohesion, would be prescribed in the regulation, and so that would remain because it would be there in regulation. But as Ms. Sheehan has indicated, there would be no Royal Commission to provide information to after that time.
So if we then turn to the criminal code defence, so the Schedule 3 criminal code defence applies to every Commonwealth Royal Commission, not just those prescribed under Part 4A of the framework.
That's correct.
So we've been talking about everything that is in relation to a Royal Commission prescribed under Part 4A of the framework. And just confirming this Royal Commission is prescribed under Part 4A.
Yes, the effect of the bill will be to prescribe.
Prescribed before Royal Commission,
so
exactly.
You won't have a gap, that's the intention.
Correct,
you won't have a
exactly,
gap between
yes.
The bill passing and it being prescribed.
Correct. Now, the effect of Schedule 3 of the Criminal Code, it becomes permanent upon enactment, correct?
Yes, that's correct.
Okay,
Yep.
So can you explain why the defence in this case is not limited to prescribed commissions, so you have the consistency throughout the Act, thereby aligning it with the accountability framework in Part 4A? I was just trying to work through, this is a permanent change to national security architecture versus what we've just been talking about. Why was that?
So this gives effect, as I as I did indicate earlier, Senator, to recommendations that came out of the AGD secrecy review, and one of those recommendations, recommended 7, was about went to this issue. It is not. It applies in general to the secrecy offences and is part of the broader package that Ms. Billington-Tavares has mentioned will be coming.
Yes.
So that has a broader application. It's correct that it has a broader application for every Royal Commission, and that is consistent, as I understand it, with the recommendations that and the broader review of and the reform that will to the secrecy provisions that the government has committed to do.
So once the bill passes, the Criminal Code defence automatically applies to any future Royal Commissions established by letters patent. No regulation is required, etc.
Not for that.
Is that appropriate that there's no scrutiny by the Parliament
Of
this
whether-
particular provision? It's going to become permanent change to the architecture.
Commissioner, Senator, sorry. We say that this is scrutiny by the Parliament. This is the policy intention is to create a long-standing defence.
Can you take me through now? What is the how does this part work?
The defence would go into Part 1 to. It's in Part 5.6 of the Criminal Code. It's one of the defences that would be added into 122.5 of
Yes.
the Criminal Code. That has other defences for that apply in relation to that apply across the board, and so it's an appropriate section for where that should go. Just to talk you through how the offences work, there is a general offence in 122.4 for unauthorised disclosure of information by current and former Commonwealth officers. The way that offence works is that if a person commits an offence by communicating information that they've had by reason of being a Commonwealth officer, and they're under a duty not to disclose the information, then they will commit an offence with a penalty of imprisonment for up to 2 years if they disclose that information. There are also offences within that part of the Criminal Code that relate to communicating and dealing with information by non-Commonwealth officers as well, which I can take you through.
Yes, please.
Certainly. So the provisions require, so this is 122.4a, and a person would commit an offence if they communicated information. The information was not made or obtained by a person by reason of the person having been a Commonwealth officer, so they weren't because that would otherwise be caught by 122.4. The information was made or obtained by another person by reason of that other, I can read it to you, it's a little confusing, by reason of that other person being or having been a Commonwealth officer or otherwise engaged to perform work for a Commonwealth entity. And probably the relevant provision is in D, which says one of the following has to apply. The information has a security classification, so we're talking about national security information, of secret or top secret. The communication damages the security or defence of Australia. So this is a list of if any one of these applies, then the offence comes in.
Yes.
Thirdly, if the communication of the information interferes with or prejudices the prevention, detection, investigation, prosecution or punishment of a criminal offence. And the fourth one is relating to the communication of information harming or prejudicing the health of or safety of the Australian public. So there are these offence provisions that exist in addition, and that's 2 of them, but there are further ones that exist in relation to the secrecy of information, and they are in the Criminal Code intentionally because they apply across the board, and there are these specific secrecy offences that apply to current and former Commonwealth officers. So there are, then, to talk you through it, a range of existing defences that exist under 122.5 of the of the criminal code. It applies to things that you might take for granted but is important to identify. So it includes, for example, information that's already public, information that you wanted to communicate to an integrity agency. So that's the Inspector General, for example, the Inspector General of Intelligence and Security or the Commonwealth Ombudsman or a range of other integrity agencies. And subject to those conditions being met, there is a defence that is available there. There are further defences, and in that way, this additional defence will apply to information that is communicated to a Royal Commission where the person reasonably believed that the relevant information was relevant to the Royal Commission's inquiry, and the person communicated it really for the primary purpose, so that has to be that's the criteria. The primary purpose is to actually have communicated it to the Royal Commission. So that defence sits alongside some of the existing defences that apply in that part.
Okay.
Yeah, and I think Senator, you asked about the broader policy intention and whether it was going too far, but I think that really key, as Phil has said, there's already a defence for providing such information to an integrity agency or to a court or tribunal. So it puts a Royal Commission on the same standing as
so that's
such a body.
Right. Okay. Yes. Okay. Now I understand that. It requires that the person, can I just confirm, communicated or dealt with information for the primary purpose, and that is I'm assuming defined term there, of communicating it to the Royal Commission. Who determines whether the primary person, the primary purpose is satisfied in that case?
So, Senator, that's not a defined term, I don't think. I think we'll take its
primary person, meaning yes, yeah. But it's got to be who actually has to prove that.
So the note to the section is consistent with many of the other defences in that. So and you'll see there's a reference to the defendant who bears the evidential burden to prove it, and it's in accordance with 13.33 of the Criminal Code, and that says that really any defendant who wishes to rely on this kind of defence, an exception, or bears the evidential burden in relation to the matter. So that is...
So, and you've actually just answered my next question. Can you read out that section? My next question was, the defence imposes an evidential burden on the defendant rather than a legal burden. What was that section you just referred to, so I can properly understand it's consistent with the evidential burden currently in the Criminal Code in relation to I'm actually invoking this?
Yes, so the section I was referring to was subsection 13.3, subsection 3 of the Criminal Code.
Can you read that out for me, just so I have it on the record?
A defendant who wishes to rely on any exception, exemption, excuse, qualification or justification provided by the law creating an offence bears an evidential burden in relation to that matter. The exception, exemption, excuse, qualification or justification need not accompany the description of the offence. So once that evidentiary burden is discharged, the prosecution would then need to prove the offence beyond reasonable doubt.
Okay. So the explanatory memorandum at paragraph 95 states that the defence is not available for speculative disclosures before a commission is established or retrospective disclosures after it concludes. So can the department clarify if a person begins gathering classified material in anticipation of a commission being established before the letters patent are actually issued, does the defence apply to that preparatory conduct?
Senator, we do have an answer to that. If you can just...
No, please. No, I know these are technical, so no, please.
So obviously the defence is only available where the person has an actual belief that the information is relevant to a Royal Commission's inquiries, and a reasonable person would have that belief. They can't rely on the defence if they communicate, remove, hold or deal with information that has a remote or unclear link. So obviously, in anticipation of some future Royal Commission is probably...
I know a Royal Commission is going to be announced, but it hasn't been announced. I start gathering the information. Is the switch on, though, when actually the letters patent are published?
The In relation to the Royal Commission and the immunity offences,
Yes.
the immunity, the Royal Commission must be prescribed by regulation.
It must be prescribed by regulation,
and so
okay.
that applies to that. But if we're still in the realm of 122.5 defences, it applies to any Royal Commission within the meaning of the Royal Commissions Act, and so that would, in terms of the defence, apply from the date of establishment of the Royal Commission. So you're not waiting on a regulation at that point.
Yep.
Which is the letters patent.
Which is the letters patent.
Yeah.
Yeah, so, and apologies. So, yes, the defence only applies to royal commissions that have been established. It wouldn't be available to people claiming to handle information for the purpose of providing it to a royal commission that may potentially be established in the future, or that was previously established but concluded its inquiries.
So the defence does not apply where the person has no reasonable grounds to believe the information was relevant to the Commission's inquiry. Is relevance assessed by reference to the Commission's terms of reference or by a wider standard of what might conceivably assist the Commission's work?
I think we would say it's...
I'd say ultimately that's a question that's determined by the court. I mean, the person bears the evidentiary burden, the defendant bears the evidentiary burden. I think it would be something also considered by the CDPP when they consider whether when they would consider the prosecution and the availability of defences under it. So it would need to be considered, but ultimately it would be the court who would have to make a determination as to whether something was relevant information or for a relevant purpose.
And just on the DPP, did you consult with the DPP about the Schedule 3 defence and in particular about its interaction with National Security Information? Or should I say, hold on, the National Security Information Criminal and Civil Proceedings Act and its implications for the prosecution of future secrecy offences?
So the CPP has been involved in the broader secrecy review process, and so they're absolutely part of that, being consulted on it, and this is reflective of that.
Okay. If I go back to the Minister's second reading speech, it states that the Schedule 3 defence treats royal commissions in the same way as courts, tribunals and integrity agencies, which is what we were just talking about previously. Can you just identify for me any difference between royal commissions and those bodies that would justify treating royal commissions differently? And if not, why not? And why has this actually taken so long to actually come before us?
Sorry, Senator, there were just a number of questions there. I will take the first one, which I think is what difference does it have between this provision and the other relevant, the courts and integrity provisions? So I will just take you to that. I will say that, yes, this is, as I mentioned, consistent with the intention of the outcomes and the recommendations of the AGD Secrecy Review and the other that I mentioned earlier.
Perhaps, Senator, we've taken you through some of the powers that royal commissions have, including the ability to hold people in contempt, but also obviously the ability to compel information. So in that way, they're very much court-like powers, but obviously established under different legislation. So yes, some similarities and some differences.
But just going back, this was one of the recommendations coming out of the Secrecy Review?
Correct.
Okay. Can I just also ask then, in terms of going back to my whistleblowers, the Schedule 3 Criminal Code defence potentially covers people who bring classified information to the Commission without agency approval? Yep.
Yes, it could.
But it covers only Division 122 of the Criminal Code. It doesn't cover the agency-specific secrecy obligations.
That is right.
Under the relevant acts that we've been talking about. Can I ask why that gap? Is that an intentional gap? Was consideration given to extending protection to those specific agency secrecy regimes?
So Senator, I think that 2023 secrecy review identifies, I think, that there are over 800 secrecy provisions across Commonwealth legislation. So the work has been done on the criminal code provisions because they do capture a fairly broad subset of Commonwealth information, as Phil has taken you through the range of offences. We would say that the difference is the strong protections in the bill that provide the immunity, the civil and criminal immunities under those relevant agency acts, because they anticipate that the information is brought forward in the right way, as in accordance with an arrangement for the purpose of a prescribed Royal Commission. So you're right, on a Venn diagram there's overlap, but not full overlap, but that is purposeful because I guess the unlock of these really serious secrecy provisions across agency legislation of their nature are worthy of this scheme that sees information provided in accordance with agreed arrangements.
Okay, I'm just trying to work through what just the gap again, because that was raised with us.
Yeah.
Was consideration given to providing an immunity rather than merely a defence?
Senator, I'm not sure there's much practical difference in terms of how it is pled. I will defer to people that have more experience of the actual pleadings than me between the immunity and the defence. I think my understanding is that both would need to be pled by.
So the immunity
by the
doesn't prevent prosecution, is what you're saying. I can still be prosecuted, but I have to plead immunity, as opposed to I can be prosecuted and obviously raise a defence. I had a slightly different understanding of that. So can I just check, does the immunity prevent prosecution, or I can be prosecuted and then I have to plead immunity?
So my understanding is that section I read out to you before from the Criminal Code, the 13.33, will also continue to apply in relation to, so that obviously applies to defences, but it also would apply to immunities. So a defendant who wishes to rely on any exception or exemption or excuse, and my understanding is that includes an immunity.
Okay. So
creating the offence. So justification provided by the law bears the evidential burden in relation to that matter.
Okay. Would an individual who's covered by these new provisions receive any legal assistance to appear at the Commission? How's that going to work?
So Senator, the bill provides for the provision of this particular information, intelligence and operationally sensitive information. The bill does have provisions for a person to seek legal advice and legal representation. That's at 6 PE. And again, it provides a clear ability to use or communicate that type of information for the purpose of receiving legal representation. So this is just making sure, again, that process can be undertaken in a safe way. I think, though, your question is about actual access to financial assistance. So, Senator, there are, the department is responsible for establishing both legal financial assistance schemes for people who are providing information to appearing before the Commission compulsorily, but we are all, and that has been established. But we are also very close to establishing an independent legal advisory, funding a legal advisory service for people who wish to get legal representation or legal advice on submissions or disclosures they wish to make.
It's very serious in terms of if I provided you information not in accordance with protocols. And the arrangements. Right. So can I just confirm that then? So in terms of Michelle and you subpoena me, or however that's going to work, you issue me with the notice to produce, that scheme's already set up if I want to access financial assistance?
So the legal advice scheme applies to any individual that might or organisation that may wish to engage with the Royal Commission.
Yes.
And the legal financial assistance scheme is there to support individuals who have might have been subpoenaed to appear at a hearing.
Okay, and so did you say they're both up and running, or one they've been finalised?
Sorry, no, the legal advice service is very close to up and running.
Okay.
The financial assistance scheme is...
When do you anticipate I'll be able to, as a person, I can make application under either scheme?
Yeah, in the coming weeks.
In the coming weeks.
We understand, though, that there are, certainly there are other funded services that people can reach out to in the meantime. These are just the Commonwealth's kind of specific arrangements for.
Who approves under the legal advice scheme and the financial assistance scheme? Who will approve the financial assistance or the legal advice being given?
The legal financial assistance scheme is approved by a delegate within the department.
Okay.
And
when you say a delegate within the department...
Sorry, within the Attorney General's department.
So the Attorney General's department, not the Royal Commission Secretariat.
It's a scheme that's administered by the department.
Yes.
And so that those decisions are made by a delegate.
Okay. Is there any guidance?
There is.
Are you able to table that for us?
Yes, it's available publicly on the Attorney General's Department website, but we'll make sure that link is
Thank you very much. And just, I'll have a look at it, but is there a cap in terms of what I can actually access, a financial cap?
There is, Senator, but let me come back to you if I can.
Oh, yeah, no, absolutely. I'll ask another question then.
Sure.
I am voluntarily, I've now read the arrangements. The Royal Commission has not approached me. However, I do have information that I believe is relevant to the Commission. Is that the financial assistance scheme? No.
No.
I voluntarily want to give you information. It is going to be relevant. I'm genuinely participating in the Royal Commission, but I do want to get the legal advice just to make sure I understand my obligations under the arrangements. How does that happen?
That would be the legal advice scheme.
Yep. Oh, that's the legal advice scheme.
That's
okay.
Right.
So that's for people who you're not actually personally calling, but I want to come forward and give information. I can actually access it through the legal advice scheme.
Yeah. And the intention, Senator, there is people are provided with free information, legal advice and assistance really to help you as that individual, hypothetical individual, to understand their legal rights and options for engaging with the Royal Commission. And so what the department is doing is engaging with external legal assistance providers really to determine who's best placed for that. And that as Ms Williamson de Vries has mentioned, will shortly be finalised.
Thank you. So again, to go back to use a term that I have been using, potential whistleblowers would have access.
They have access to information, legal advice and other support.
Okay, thank you very much. Just in terms of the drafting, etc., the Inspector General of Intelligence and Security has statutory oversight responsibilities for the 6 intelligence agencies named in the bill. The bill creates no explicit IGIS oversight role in relation to the Commission's handling of intelligence material. Why is that?
As far as I understand, it's not within my understanding of the IGIS Act, the relevant act, that it's not within the IGIS's statutory functions.
No, but we could have amended the statutory functions.
But it is within their statutory functions to oversee the as you mentioned, the operation of those intelligence agencies, and but it would not. It does not include the Royal Commission as such.
So, just how will that then work? Secure information is being provided. Who does oversee the Royal Commission in terms of the handling of that information?
So I'll let the Royal Commission speak for themselves, but the requirements of the Protective Security Policy Framework under which Commonwealth entities hold information would apply across the board, and that is, as you'd be familiar with, Senator, a very important government restriction policy on how that classified information is held. And that's why it's so important, of course, that it is reflected in the arrangements that the Royal Commission is to hold in accordance with PSPF requirements.
Yeah. And
again, though, no, sorry, Michelle, I'll just jump in and then I'll... Again, though, what's the oversight body to ensure that that happens, given when you look at the letters patent and in particular this particular term of the letters patent, this is very serious. What we are doing with this bill is obviously incredibly serious. The information being handed over, it is intelligence information at that top secret level potentially. So just in terms of that oversight of the Royal Commission, is there any oversight?
There's not an oversight body for the Royal Commission in the same way that there's not an oversight body for courts or tribunals that might also receive classified information as well.
No, okay, that's the answer. Okay. Was the IGIS consulted on that?
No, we had provided the IGIS with a copy of the bill and an opportunity to comment, but...
Could you just confirm, and you can take it on notice for us, was the IGIS consulted about whether or not any oversight role was required, whether or not the IGIS should provide that oversight, whether or not we should change that act to actually ensure that oversight was given? Should be given?
Well, we can confirm that there was no consultation, but we can take on notice.
Oh, so there was no consultation with the IGIS
about those issues.
Okay.
That's right. Yeah.
Yeah.
But there was a consultation on the bill.
This is slightly left field, but the definition of operationally sensitive information includes information provided by foreign governments. That is my understanding. Where those governments do not consent to public disclosure. Is that correct?
Read through all the provisions.
Yes, that's right, Senator. That's the wording that is used in the definition of operationally sensitive information.
So just in terms of the Five Eyes partner intelligence, how do you satisfy yourself that they understand that this information may well be provided over in accordance with all of the protocols?
Senator, sorry, Parker.
Senator, so in relation to Five Eyes partner intelligence, so if we are referring to the 6 intelligence agencies covered by the intelligence arrangement, then that is covered by the definition of intelligence information.
Yes.
And foreign government information under the intelligence arrangement, so it's subject to those more stringent protections. The definition of foreign government information as part of operationally sensitive information applies then outside the context of intelligence information as it relates to those six agencies.
Thank you for that. Can you then take me through how that practically works in relation to the act that we're looking at, the arrangements?
So in which regard, Senator? Sorry.
So in terms of, if I'm handing over top secret information that actually captures Five Eyes partner intelligence, do I have to disclose to the Five Eyes partners that this is happening?
Senator, I think that's probably best raised with agencies, and if you're not able to get that information, we could take it on notice.
Would you mind taking it on notice? I'm not sure I'm going to be able to get that information.
It would depend on their own relationships with foreign partners and the processes of kind of consultation or consent to release, but of course that is something that is dealt with in the court context as well.
Did you consult with, and you've given me an extensive list of government departments that were consulted with, but just in terms of the foreign intelligence dimensions of the bill, were the Department of Foreign Affairs consulted in relation to the foreign intelligence dimensions of the bill?
The Department of Foreign Affairs was consulted on the bill, yes.
And on the...
And on those specific,
Oh, sorry,
well,
yes,
on the
the
bill,
arrangements.
yes. And on the arrangements.
Mm-hmm.
Okay.
And Senator, just to come back to your previous question, I think an important point to make is, and I'll take you to section 10 of the intelligence arrangement.
Yes.
Is that the arrangements fully preserve, as you would expect.
Can you, sorry, section 10 and we're looking at?
Section 10, and in particular paragraph 10.4. So at the point we get to publication in particular, but there are similar provisions for the hearings and the like, preserve the ability of agencies to make all of the standard applications for public interest immunity, non-publication, or the revision or removal of particular materials. So I think what we've been discussing up to this point is about how information is provided to the Royal Commission, but the arrangements also put in place protections around what might be publicly disclosed, either in a hearing or in the Commission's final report. And
Sorry, that's a very good distinction, and I very much appreciate that. I'm now looking at 10.4. In the event that the Commonwealth, including a relevant intelligence agency, capital I, capital E, identifies intelligence information in the content of any publication, the Commonwealth or relevant intelligence agency may, as necessary and appropriate, having regard to the nature of the intelligence information, request the revision or removal, of the intelligence information, apply for non-publication directions, make a claim. Thank you.
Yes.
So that's how that's taken care of.
Yes, and just to dot I's and cross T's, Senator, paragraph 10.2 provides that the Royal Commission has agreed to consult intelligence entities prior to publication.
Correct. So that's going to be my next question. How do I know?
In a similar way, for example, to the manner in which this committee is required to.
Understood. Okay. And obviously then, if I need to go down the path of saying to you I need to invoke section 10.4 A, B or C, you would need to then obviously go through that process before publication. So you wouldn't have you just have to delay publication until that process had been gone through.
So, for example, if the Royal Commission wanted to include some information in its report, it would be consulting with those agencies prior to publication.
Okay.
And that reflects that comes from the requirements in the letters patent for the Commission to protect information, intelligence information and operationally sensitive information.
Thank you.
That's paragraph H of the letters patent.
Sorry, I'm going through all of my questions because you've... please jump in.
Excuse me if it's been answered, but I just had to step out just before. I was just hoping the department might be able to explain to the committee the reasonable excuse amendments.
Certainly, Chair. Just one moment.
Okay, good. So it hadn't been answered. Thank you.
So I might begin and then hand to Ms Williamson to read. So one of the things that this bill does is to clarify the scope of the reasonable excuse defences in the Royal Commissions Act. So the bill makes clear that a person cannot refuse to appear, provide documents, give information or answer questions on the basis that doing so would, before a Royal Commission, on the basis that doing so would breach a secrecy provision. What it means in practice is that we think that that intelligence and operationally sensitive information must be provided to a Royal Commission when required. So you're not able to claim in a reasonable excuse is that you are going to breach a secrecy provision. So we've strengthened that component.
Senator, this addresses an issue that I think had arisen in practice in the Defence and Veteran Suicide Royal Commission, where people, and particularly current and former Commonwealth officials, defence officials, didn't actually feel confident. They didn't feel like the secrecy provisions were completely unlocked, even where they had been compelled to give evidence. So Phil has given you a good overview. Maybe I can take you to the explanatory memorandum at paragraph 37, which really just demonstrates or shows that reasonable excuse exemptions that are currently defences to certain offences for failing to provide information or give evidence to the Royal Commission do not apply where a person, where a person would seek to rely on a secrecy provision as a reason to refuse providing, in particular, intelligence or operationally sensitive information in response to a requirement from the Commission.
Oh, thank you. Because I was going to ask, why are they important? So I think there's some...
I think it's really grounded in the practical experience of recent Royal Commissions.
What was the workaround that the Veterans Royal Commission ended up putting in place?
We'd have to check.
Would you? I mean, there was a workaround that they put in place.
Certainly,
It's their
many people gave evidence and information. I'm not sure if it was kind of practically resolved. We'll come back to you on that.
Chair, Senator, if I might add from the Royal Commission's perspective, this...
Sorry, what was that?
Sorry, if I might add just from the Royal Commission's perspective, this amendment is particularly important in relation to the TIA Act, Surveillance Devices Act, AML-CTF Act, that we mentioned earlier. One of the limbs of the definition of reasonable excuse in the Royal Commissions Act is an excuse which would excuse an act or omission of a similar nature by a witness before a court of law. The secrecy provisions in those small number of acts that we've been referring to in particular, they quite explicitly deal with when information is or isn't admissible in court, and when it can be given in evidence by a witness, which makes those secrecy provisions particularly challenging for the Royal Commission because they give rise to a reasonable excuse. So from the Royal Commission's perspective, this amendment is particularly important to enable us to access information under the TIA Act in particular, but a few of those other acts that have similarly quite strong secrecy provisions that deal with evidentiary matters.
We're lifting reasonable excuse and we're putting in place the immunity separate to the Commonwealth Defence, but it still has to be done in accordance with the arrangements. That's the whole point of the arrangements.
Correct.
Yep,
That's right.
exactly, which we've been talking about.
Yeah, okay. And I'll just pick up from that point you just made too. I mean, I guess without these amendments, is the Royal Commission concerned that it may not receive all the information needed to finalise its interim report?
That's right. It's important for the amendments would then enable the provision of information that we haven't been able to receive to date.
And what are the consequences of not progressing some of these in a timely manner?
Well, it would mean that there could be critical information that's held by the agencies that would be relevant to the Royal Commission's work that we wouldn't have the benefit of receiving.
And in terms of your engagement with the NIC being, I'm assuming, positive, you've had a constructive...
With who?
With the NIC agency. The NIC agencies, have they been constructive with the arrangements?
Yes, there's been very constructive engagement with the agencies.
Sorry, there's more acronyms, I know.
No, I thought it was Nick, and I was thinking, who's
No,
Nick?
No. Capital NIC.
Who's Nick? I haven't mentioned you yet.
All right, I have to go back to you.
No, and thank you for that, absolutely. I've only got...
Just be careful that jacket, I think you're stained.
I'm already starting to...
Yeah.
I've already started to blue myself. Okay, thank you, Chair. Just to now start rounding out this entire discussion, you've been very helpful. Thank you very much. Very, very helpful. Just in terms of if a Cabinet Minister was called before the Royal Commission, in terms of Cabinet deliberations, how does that work? Can they or can you force them to discuss Cabinet deliberations at this particular Royal Commission?
So, Cabinet material, may be subject to a public interest immunity claim, so that might be a claim that's relevant to information.
So yeah, that's what I just want to check. So nothing here.
And I mean that's not unusual, but for Royal Commissions have in the past sought information that that had been before Cabinet, and commissioners have made rulings on the availability of PII claims. So that's I suppose a well-trodden path for Royal Commissions to consider that.
Yeah, and Senator, we'd said nothing in this bill upsets the ability or the power or any defence to providing such information.
We've talked about the lifting of the reasonable excuse. If the bill passes, the immunity and the defence get put in. Can I understand, it's a question that's sort of at the back end of this, are there any limits on the evidentiary protections provided in the bill? They've got to be done in accordance with the arrangements. The Royal Commission has to be turned on. Once the Royal Commission is turned off, for use of a turn of phrase, it no longer applies. Are there any other... Is there any other lacking of any form of protection?
I don't think so, Senator. And again, it's 6PD of the bill that clearly sets out where the protections come in. And as you say, it's both voluntary and compulsory provision of information. It must be that type of information, intelligence or operationally sensitive, and it must be consistent. And then subsection 2 of that provision provides protection from liability, and subsection 3 provides a use immunity that information is not admissible in any proceedings.
Can you remind me, has anyone previously been charged with giving information to a Royal Commission which was considered secret? Trying to rack my brain.
I'm not
It's been probably a long time since the Royal Commission had needed to deal with classified information.
Yep. Or the Veterans, yep.
And
the Veterans Royal Commission, people came forward obviously and wanted to provide information. Just in terms of you receive information, you uncover some form of other wrongdoing. Do the protections prevent prosecution for unrelated wrongdoing discovered during the Royal Commission? You're reading it for the purposes of the Royal Commission, but you actually realise something else has happened?
Are you talking about a prosecution of an individual?
Yeah.
Of a separate individual, so one individual provides the information.
Actually, it's relevant to the Royal Commission, but it actually discloses something else has actually happened, separate to the Royal Commission.
So the protections that are given under the bill are related to the secrecy offences alone, rather than any other conduct. So the bill does not speak to protection from liability for
anything else that they
offences other than things other than secrecy offences, breach of secrecy offences.
And Senator, I'd also just point to Section 6P of the Royal Commissions Act, which deals with the circumstance where a Royal Commission itself identifies information of an offence and provides that the Royal Commission may communicate relevant information to an appropriate authority.
Just in terms of the classified information, I come to you, I want to give you the information, I do it in accordance with the protocols. It's not relevant. What then happens?
I guess...
Have I given you the information? Because you have to make the determination upon which it's relevant or not. You determine it's not relevant, but I have disclosed the classified information.
So the disclosure itself would be protected, would receive, if you've done it in accordance with the arrangement, would be protected. The question of whether the information is relevant to the Royal Commission's functions is obviously a matter for the Royal Commission to determine. But the protection of the bill is for the provision of that information to the Royal Commission. So it doesn't speak to the question of how relevant that information was for the Royal Commission.
So the only other question that I then have that flows on from there is, can the defence be used improperly to justify unauthorised disclosure of classified information? I really want you to see something. I believe it's relevant to the Commission. It's not. But I really need you to see this information.
I think we would go back, Senator, to the reasonable belief in the criminal code.
Yeah,
defence.
okay. Can you just take me through that again, just for the record?
Yes. It's a defence to a prosecution if a person communicated, removed, held or otherwise dealt with relevant information for the primary purpose. So we've spoken about those two meanings. Primary purpose of communicating it to a Royal Commission within the meaning of the Royal Commissions Act. And at the time, the person reasonably believed that the relevant information was relevant to that inquiry. So it's both the person's own belief, but also whether it was relevant is based on a reasonable person making
Senator,
that assessment.
That also applies in relation to the immunity protections. So in 6PD 1A Roman 1, there's a reference to the person reasonably believing that the information or document is relevant to the matters of the Commission. And that, again, has the same note that I mentioned earlier about subsection 13.3, meaning the defendant has to prove that they have the evidentiary burden first. So before it flips to the prosecution. So that term, that reasonable belief, might go to your example of a person who does not have a potentially does not have a reasonable belief. Yeah.
Chair, the good news is the officials have been so diligent, and I have to say you've been absolutely outstanding in terms of allowing me to have a free-flowing conversation with you, because I was jumping around, but I very much do appreciate everything that you've given us here today.
Thank you for that, Senator Cash. I'm glad to hear that. Thank you very much to all our officials. If there were anything, if you took any on notice, can I just ask you please get something back to us by 9 a.m. Tuesday? I'm mindful it is a long weekend, but if you can try. Sorry?
I was going to say certain parts of Australia, in other parts of Australia.
Here in the ACT, but obviously there is tomorrow. But if you can get to us as soon as you can, that'd be awesome. On that note, being no other witnesses this evening, I declare this public hearing closed at 7:30.
Thank you.
Sorry, I declare this public hearing closed. Full stop.